Hello viewers, very welcome from my live show. Today I'll speak about how to divide money and property during divorce, or what is your right over the family asset capital, what is the matrimonial property, whether the property acquired before the marriage is within the definition of a matrimonial property and subject to division of in divorce. What about the inheritance tax? Inheritance one spouse receive from his parents, whether the matrimonial property or family asset is divided is exactly 50-50, or there is a change. So that's the question I'll discuss about, and also show you how to start financial remedy application to get a court order, which form you should select and which form you should fill up and submit to the court to start the family financial remedy proceedings to get your asset from the other spouse or division of the family property. So stay with me. I'll be back after a short break. Viewers, my name is Sohail Ahmed. I'm a solicitor. This information is not a legal advice. Please speak to a solicitor, or if you need any help, please feel free to contact and make an appointment with me. The purpose of this video is to share information so that you can get some idea where to start and to know your right on family property in case of divorce and separation. Now, the question is, what actually constitute a matrimonial property? Now, matrimonial property means the property which is acquired during the marriage or before the marriage some extent, and which is subject to division, where the court will divide your property asset or any income or saving to divide equally or fairly, whatever it is. Now, the matrimonial property is very important for both spouse, because all of you, whatever age, whatever time you spend together, now once the time life come to end and you decided to divorce or separate from each other, then the time is also to decide how to divide your property. Now, the starting point, the question is whether the matrimonial property means the joint asset or sole asset. Now, one of the confusion is it doesn't matter whether the property is in the name of one spouse or joint or both spouse, as long as it is acquired or within the matrimonial property, whether you have acquired during the marriage or before the marriage, but not inheritance, then it is within the definition of matrimonial property and subject to division. Now, the question is whether the court will divide is 50-50, or court will sometime change the position of 50-50. Well, it is used to be the position of the court to divide matrimonial property 50-50, but following the court decision, I think so far is Ward versus Ward, is the decision is the division of matrimonial property is not 50-50, but what is fair and just for the both party. For example, if one spouse is in the care of the children, underage children 13 or 19 or under 18 years old, then the mother or the father who is in care of the children has more burden for the family, and they are more likely to get more than 50%. Or also quoting to take into account the circumstance of each spouse, or the including the contribution. Okay, so all this question court take into account, and what is fair for both party, and what is fair, what is just. This was the current position is. So it is not strictly the 50-50, but what is fair for this fair principle is followed by the court for the division of matrimonial property. Now, in terms of inheritance or gift, which is not a matrimonial property and is not subject to division. However, court may take into account if one spouse get a very substantial inheritance from his or her parents, and other spouse is position is not good enough compared to the for one spouse who get the inheritance. Court will take into account, however, the inheritance is not subject to a division, or the court will not take into account as a matrimonial property. Then how to start the proceeding in terms of court proceeding. Now, whether it is only the property or any other thing. Now, when you divorce, is not only the property or asset to divide. Court also need to take into account the income. So it is important for the spouse to claim maintenance from other spouse, because, for example, when the court divide the property, matrimonial property, for example, a property, then the court will also take into account the other spouse income, other spouse ability to get mortgage. So all this is important, and I think is for an applicant, for a spouse, it is important that stage to speak to a lawyer, because might be you see that I have only one property, so let's put it 50-50, but rather than to put and make a decision by yourself to divide 50-50, I think it is important to speak to a lawyer, because might be your income is less than your other half as income. In that case, there you have a chance to get more, because income is important. For example, if you're female, maybe your earnings is less than husband, or husband, if you're a husband, you are a man, your wife's income is higher than your income. So in that case, the court will make an adjustment which is fair, because in the foreseeable future you will earn more money, and that will put you in a better position than your other half. So this is important to take into account in income as well. So how to start proceedings, and then I'll take into account basically what are the other asset and how the court will decide what is how to divide the position. Now, to start the proceedings, first is a mandatory requirement to attend mediation. So I encourage also, and the court encouraged to settle this matter by way of negotiation, and financial remedy is very expensive and very complex in terms of hearing, and the legal cost is huge. So I always appreciate and also encourage people on divorce to settle to reach an agreement before go to the court. Court will put all the effort as well to settle, because on the first or second hearing, which is first dispute resolution hearing, the court will try to negotiate between the party to settle the matter without a contested hearing. But if the court failed, then of course it will proceed to final contested hearing for 1 full day or 2 days, depend on the amount of your property. Now, if you want to start proceeding, as I said, you must attend the mediation, and if you cannot reach an agreement, or if the other party not attend or refuse to attend, then the mediator will sign a form, a page that you try to settle this matter out of the court by way of mediation. And why it is important to attend the mediation, because if you don't attend the mediation, or if you attend the mediation and other party doesn't attend, then more likely you will get a cost order against your other spouse. So if you attend the mediation and other party, your husband or wife, doesn't attend, then the mediator will write a form, he will sign it, and he will confirm that, well, other party refused or failed to attend, or whatever it is, or cannot reach an agreement. Now, in the end of the final hearing, the solicitor will submit a cost form, which is a statement of cost, and then the solicitor will ask the court to give an award for cost order, because 10,000 or 5,000 pound legal cost, and we can give an argument, well, look, my clients try to settle this matter by way of negotiation, but the other party conduct of unreasonable, they refuse to engage and settle this matter by way of mediation. If the other party would attend mediation, that might be my client don't need to be paid that amount of money, so you will get more likely get a cost order against your other half. So it is important to attend the mediation. Now if the mediation fail, then it's time to make an application to the court. And then what you need to do first, you need to make an application to the court, and the form is I'll show in the screen. This is the form what you need to fill up. Notice of intention. Notice of intention to proceed with the financial application to which the standard procedure. So this is the form. It's a form A. So if you Google it, you'll see in there this form A, notice of intention to proceed financial remedy application. That this form you need to fill up, and this form is not much information actually. This form is very basic information. So you don't know the court case number. So if you have the if you already applied for divorce, then you can give the divorce case number. It's the same case number, and then here I need to court name. So for example, if it is East London Family Court or Cardiff Family Court or Milton Keynes, whatever it is, you need to write the court number, and then the name of the party, and then nature of the application. So this is basic information and what you are looking for. Now this section is very important in terms of financial remedy application, and I think you should concentrate very carefully to select it. Now of course, if it is divorce, you need to apply for divorce. If it is dissolution for civil partnership, you need to select accordingly. And then what will remedy, you should click all of this, whatever applicable, but I'll recommend an order for maintenance you should look for, and you should a lump sum order, property adjustment order. If you have a pension, if the other party, if you think that have a pension, you should also seek an order for pension sharing order. So all these remedy you should seek in the financial remedy application. It is very important, because if you miss, you will lose it. For example, if you don't apply for a pension sharing order, might be you will lose to an opportunity. So it is important to select all of it which is applicable in your case. And then the address of, if you know the property address of the property, you need to give the address of the mortgagee. And then also if you reach an agreement anyway, so whatever, then you need to select. If you like, if you want to apply for a consent order, if you have any children also, you need to select and give their details, because the court need to take into account the children age and who is responsible to look after, and then accordingly court make a fair order, adjustment order in the court. And if you need more pages, you can accordingly add it and then sign. And then what you can do, you can send it by post to the nearest family court within where you live or where the other party lives. So I will recommend to send to your nearest court. So this is the form basically, which is first application, form A, notice of intention to financial application, which is standard procedure apply. So this is the form you should submit it to the family court where your divorce case is going. So once you submit it to the court, you don't need to send anything else at this stage. So once you submit it, then what court will do, you will receive, the respondent will receive a form A plus court direction, and you will receive a court direction. More likely court will give you a direction within 3 months or 1 month or 28 days, or will specify a date. Within this time you need to exchange and submit the form E. So you need to fill up a form E. Now form E is very long form and it's a bit complex if you have different types of property, asset, maintenance, pension, saving. So all the information you need to give in the form A. Form A is basically, I said, your whole life. You need to write when you get married, what property you have, what inheritance you have, how much you spend for your life, how much money you need for for living, how much money you spend currently, what will be a current position, and what will be your position after divorce. So all this information, the valuation of the current home, valuation of your pension, the outstanding mortgage, the equity of the property, all this information is you need to write in the form E. Now that form might be complex if you have if your matter is if your property is one or two property, have pension, saving, inheritance, all these things, and you have a children. So at this stage, I think the best thing is you need to consult with a solicitor who will be able to help you. Otherwise you may lose more money from because of lack of legal advice. So once you submit the form A, then sometime what the party does, that party doesn't disclose their all this information, property, saving, and what we do at that stage, after that probably court will fix a date for hearing, and on that hearing date, which will be the first appointment hearing, so on that day court will give further direction, which is basically disclosure direction. So if you think that the other partner have a bank account where he has a saving, or there is a substantial transfer, or if you think he is hiding something or she is hiding something, then you should ask a disclosure direction from the court at that hearing, and the court will give disclosure. So more likely, for example, I will seek 2 year bank statement from other party to send me, and I'll send as well. Once we receive the disclosure document, and I can also ask different types of question about how much inheritance, for example, you receive, how much pension you have, whether you will have a promotion, what is so all this question I can ask other party. So how much money he has because you live with him. If if you have any suspect where he have saving, or he have a other property in back home, for example, majority of the people from Asia or Bangladesh, Pakistan, they have asset in back home. So you need to, the spouse who lives here, she doesn't know about it. So you need to ask your solicitor. Then we can ask the court to direct the other party to disclose his property in Pakistan, Bangladesh, India, wherever, or Ghana. So the party has to disclose this property. Now at this stage, if the party doesn't want to disclose, but they think maybe I will not able to find what property the husband have in Ghana, in Accra. This is what they do. Some people do like this. Then if he is dishonest, if he doesn't disclose, but it, then what I'll do, he will not disclose the information. I'll investigate it. I'll appoint a private investigator and bring the document from Ghana, from Accra or Ghana or wherever it is, and then we'll produce to the court that this is the property he has and he didn't disclose, and he will lose his credibility, and court will dislike these types of behavior or conduct. So that's why I said financial remedy application is a bit technical, and you need legal advice sometime. So you should speak to a lawyer in terms of financial remedy application. Anyway, once the disclosure complete, then will be first dispute resolution hearing. That is, the hearing will be presided by a judge who will basically mediate this matter, negotiate this matter to settle between the party without a final hearing, without going to full contested hearing. Most of the case settle at this stage, and the cost is less as well. But if this matter is failed in the first dispute resolution FDR, then the next stage is court will give direction again on that hearing to disclose the information again, disclosure direction plus section 25 statement. The party need to give section 25 statement, party need to give position statement, and if require any further disclosure, the valuation of the family home, valuation of the other property, valuation of the pension. So against the court will give direction, and then a final stage go to the final will be final hearing, and then later then the final hearing both party will attend, and then the party will give a statement at the hearing. The counsel will or solicitor will give their submission based on the disclosure, based on the conduct, based on the information in form AE, and then accordingly judge will make a decision which is fair for the both party. So this is how the court will make a decision for the matrimonial property, division of asset, house, or if you have any property back home, or if you have any income which is husband, for example, earn more money and wife earn less money. In that case, court may order the husband to pay a certain amount of money for a certain period. For example, husband is working and he earn around £100,000 per year, and the wife is getting £20,000. In that case, or wife is in charge of two minor child, under 18 child. So until the child turn 18, the court may order the husband to pay a £5,000 or £2,000 periodical payment each month. So income order. Secondly, the court may also, for example, where there is no children but one party income is significantly higher than other party, then in that case court may order a lump sum payment, for example £50,000 to the other party to adjust the income, so that by using that money the other party can settle herself or himself. So financial remedy application is basically you need some time to involve an expertise to find out all these issue and accordingly seek a remedy, seek a court direction, and proceed so that you can get the highest remedy from the other party. So this is how you can make an application to the code for financial remedy application. Now, when you should make this application, what is the right time to make financial remedy application? Well, financial remedy application generally you should make after decree nisi, before decree absolute, because remember decree absolute is very important and a relevant date, where after that there is a remarriage trap. So if your spouse get married, then you might lose the maintenance or periodical payment. So it's important to make an application before decree absolute, but in any time you can make this application before once you make the divorce application to the family court. But generally we try to negotiate when we get an instruction from any client to make an application for financial remedy, we negotiate other party, we both party solicitor, because we understand what is likely you will get it, or what you are wrong doing, what other party wrong. So we solicitor always engaged in negotiation to settle the matter out of the court to save cost. But sometimes it doesn't work because other party is not assisting or open mind, they're not come forward to settle, rather than they're hiding here and there. In that case, the option is we have no option, we need to go to court and make an application and get direction from the court, and accordingly seek a remedy from the court to get a fair share from the matrimonial property. So this is how all about it today. So this video is just for information. I hope it will help to understand a few things about financial remedy application, or your right on matrimonial property in case of divorce. If you need any help, please feel free to contact me to the number appear on the screen. I am available in Milton Keynes or London, also any part of the UK. If you need help, we can provide support via a video consultation or a telephone consultation. Thank you very much all of you who watched this video. Have a great night.